On September 24, 1957, National Guard troops stood at the entrances to Central High School in Little Rock, Arkansas. Their rifles were pointed at a group of black students waiting to enter. Governor Orville Faubus had ordered them there. A federal court had ordered those students admitted. Two authorities, two contradictory commands. The state said no. The federal government said yes. And in that moment, the entire architecture of American power, written into the Constitution but never fully tested until then, faced its first serious challenge in the modern era. That scene raises a question that runs deeper than integration or civil rights, though those matter enormously. It asks, what happens when a state simply refuses to follow federal law? The answer lives in a single sentence buried in Article VI of the Constitution. The Supremacy Clause states that the Constitution, federal laws made under it, and treaties are the supreme law of the land. It does not say federal law is one opinion among many. It says it is supreme. Any state constitution, any state law that conflicts with federal authority must yield. That is not negotiation. That is the operating system. But this power has limits, and those limits matter. In 1997, the Supreme Court heard a case called Prince v. United States. The case involved background checks for gun sales. Federal law required them. Could the federal government force state and local officials to conduct those checks using state resources and personnel? The court said no. States cannot be conscripted into federal enforcement. You must obey federal law, the ruling clarified, but the federal government cannot commandeer your police force, your bureaucracy, your payroll to do it. That is the boundary. Obedience is mandatory. Labor is not. History offers a cautionary tale about what happens when states try to cross that boundary anyway. In 1832, South Carolina passed an ordinance of nullification, declaring that a federal tariff law was void within its borders. South Carolina would simply refuse it. President Andrew Jackson responded with a proclamation that made clear, nullification has no legal standing. States do not have the power to void federal law. When Jackson threatened to send troops to enforce collection, South Carolina backed down. The doctrine collapsed. The Constitution won. Little Rock followed the same script. Federal courts ordered integration. Arkansas resisted. President Eisenhower sent the 101st Airborne Division. Within weeks, the National Guard was gone and the students entered the school. Resistance met federal force and could not sustain itself. Yet the relationship between state and federal power remains more complicated in practice than it does in law. Marijuana exists in this gap. Cannabis is Schedule I under federal law, illegal, considered highly dangerous, with no accepted medical use. Many states have legalized it entirely. Federal law has not changed. Yet federal prosecutors do not raid dispensaries in Colorado or California with any regularity. The law remains on the books. The enforcement simply does not happen. Is this states ignoring federal law, or is it prosecutorial discretion? The federal government choosing where to spend its limited resources? The legal answer is clear. Federal law prevails. The practical answer is messier. Some conflicts persist not because courts have resolved them, but because enforcement capacity is finite. Sanctuary cities and states exist in this same terrain. Many jurisdictions limit their cooperation with federal immigration enforcement, declining to hold immigrants beyond their release dates or to share detention information with federal agents. These policies do not nullify immigration law. They do not declare it void. They simply decline to assist in its enforcement. When courts have examined this practice, they have generally allowed it. States remain protected by anti-commandeering doctrine. When courts have struck down sanctuary policies, it has been narrowly on specific grounds about federal preemption, not on any principle that states must become extensions of federal will. The pattern is this. Federal law is supreme when directly enforced through the courts, but the gap between what is legally mandatory and what is practically enforced remains real, and that gap is where much state-federal tension actually lives. States cannot ignore federal law. The Constitution does not permit it. History does not support it. Courts will not protect it. What states can do is decline to assist, and in that distinction lies the continuing shape of American federalism.